Matt Day here with Parsons, Graham and Day. Want to talk about something that comes up just occasionally in criminal cases, and that is a sentencing hearing. The hearing at which the judge will give the sentence to the defendant. By the time you're getting to a sentencing hearing, you have entered a plea of guilty or no contest or an Alford plea. You've entered some sort of plea, and now is the time for the judge to sentence you. The judge is going to consider several things at a sentencing hearing. One of the biggest things that they're going to consider is the likelihood that there will be future crimes that you commit. What is the chance of what we call recidivism, right? What is the chance that, given your circumstances, given your personality type, your history, that you're going to go out and commit crimes? So when trying to make that determination, looking into the crystal ball, reading the tea leaves, the judge is going to look at things like, have you previously been convicted of felonies or misdemeanors, charged with felonies or misdemeanors, arrested before? How involved are you in your community? What kind of job do you have, and how long have you had that job? Are you currently involved in any sort of counseling or mental health services that may be assisting you? Are you taking any substance abuse programs? Are you taking any classes? Recently, we argued for a deferred sentence for one of our clients with success. And this client had gone out and almost immediately started taking classes. He took the most extensive classes he could find on anger management. He took the most extensive class he could find on domestic violence. He enrolled in the program that was eventually going to be ordered to him anyway, and it was over halfway done by the time we got to sentencing. He was involved in counseling. He had done 100+ community service hours. So when the judge had the opportunity to look at this individual for sentencing, he was able to make a determination that this person should receive a deferred sentence and should be allowed probation. Another tool that judges use will be a pre-sentence investigation. Now, pre-sentence investigation is done by a neutral party who investigates the defendant, investigates the facts. They take a look at what the police report says. They'll look at some of the discovery. They'll get a narrative of what occurred from the accused. They'll also take a look at the accused's educational history, their residential history, their employment history. If there are any letters of recommendation or letters from people who think that the defendant is a good or bad person, they'll take a look at all that. They try to interview any witnesses or review witness interviews and put together a report for the court as to whether or not they think the individual is likely to commit other crimes or whether they're amenable to treatment. They also will look at what is the cost. So obviously, if we imprison somebody, the taxpayers have to pay to feed, clothe, and house that individual. Sometimes we just have to take on that burden because the person is that bad. But other times we can compare that cost with the likelihood that a probation sentence will be successful and that this person will not come back into contact with law enforcement. These are just a few of the things that judges look at when considering sentences in criminal cases. If you find yourself accused, give us a call today at 918-307-1529, or for more information, visit our website, www.pdtulsalaw.com.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons, Graham and Day and anyone watching this video.